Welcome everyone back. We're just slightly past prime time, but you're in the absolute right channel, particularly those viewers online who are probably going to miss the next Tagesschau Extra on Corona. But you're going to be hearing something way more interesting now. I welcome you to a presentation and panel on designing data trusts based on a purpose-based approach. We're going to have a panel of three highly distinguished speakers next. Unfortunately, Ronja Kemmer, MP, won't be able to join us, but we do have a very interesting presentation to start with from Professor Louisa Specht-Riemenschneider, hello, and Professor Wolfgang Kerber, to kick us off really. If you have ever been wondering what data trusts are and you've been musing about this slightly fuzzy concept, then this presentation and the panel is really going to be for you. You gain an exclusive sneak peek into an upcoming study. And without further ado, I hand the floor over to you, Wolfgang and Louisa. Please enlighten us and inspire us for the upcoming discussion.
Yeah, hello, also from my side. Thank you for the kind introduction. I hope you can hear me. If you cannot, then just give me a signal. I would have loved to come to Berlin today, but unfortunately, I'm a bit sick. And Pencho, thank you so much for the opportunity to present the study remotely today. You can already see from the title of our presentation what we think must be the goal for regulating data trusts, a purpose-based approach that asks which problem a data trust should solve and regulates them in such a manner that they can really function to solve this problem. But let's start with the very basics. Wolfgang, if you would present the next slide. I'm afraid I cannot see the slide, so I depend on you doing and presenting the right slide. So I guess you might have shown it now so that we can all see. Yeah, now I see the slide. Thank you very much. So please, next slide. What are data intermediaries and what are data trusts and how do they differ from each other? Data intermediaries are institutions that bring data providers and data recipients together, either by establishing direct contact between these two parties so that they can exchange data with each other. That is what I describe, or what we describe as the broker function, or by receiving data from the data provider and passing it on to the data recipient. That is what we describe as the seller function. What does data, or what do data trusts do in contrast to this? What is a data trust anyway? Next slide, please. That depends on who you ask. The definitions vary, but the different opinions agree that also their function is to mediate access to data between the data provider and the data recipients, for example, between the data subject and the company which wants to process the data. The difference between a data intermediary and a data trust is that the data trust does not act in his own interest, but in the interest of another person. He might act, for example, in the best interest of the data provider, in the best interest of the data subject, or he acts in the interest of another party according to statutes which tell him to act in this way. Hence, one can say that a data trust is a special form of a data intermediary. There are two ways to define what a data trust can be and to agree on what is necessary for its regulation. The first is to define or analyze data trusteeship on the basis of the various trustee concepts in the legal systems of the member states. So one can say our legal system requires this and that for someone to be a trustee or a trust. And now we see data intermediaries as data trusts when they meet these requirements. But if you want to find an international compromise on the regulation of data trusts or just on principles for their regulation, I think the different requirements of the different legal systems will make it very hard to go that first way. An alternative way could be to look at the cases where it seems necessary to bind the data intermediary to the interest of the data provider or to the interest of another person, and to consider all these data intermediaries as data trustees. That is what we have done. But even then, the possible data trust models differ in such a manner that each model requires specific regulation. What I want to say is, it should not be so much about the names of the phenomena we want to regulate, but about the phenomena themselves. Even if we come to call a data intermediary a data trust, that does not mean that it should be subject to the same regulatory requirements as another data intermediary that we or another jurisdiction calls a data trust. So this is our first recommendation. Avoid one-size-fits-all scenarios, one-size-fits-all solutions for data trusts. In our study, we want to show you 3 scenarios in which data trusts could be useful, and you will see that the chosen data trust model each must meet different requirements to solve the problems which occur in the 3 different scenarios. But before we proceed to these different scenarios, I want to introduce you very briefly to the 4 different basic data trust models which I have developed together with Aline Blankets before the study and on which the study is based. Next slide, please. We first distinguish between voluntary and mandatory use of data trust and between centralized and decentralized data storage, whereby in the case of decentralized data storage, the data trust acts as a data pass-through entity, so we call it. Let me give you some examples. Personal information management systems, for example, at the moment store data in a centralized way, but they are for voluntary use at the moment. Thus, they are an optional data host. If the data would be stored in the user's wearables or their mobile phones and would only be transferred to the PIMS when the data processor asked for this data, and the PIMS forward this data to the data processor, they would act as an optional data cache. And if their use would be mandatory, for example, because their instructions need to be followed by data processors, they would be a mandatory data host or a mandatory data cache, which depends on where the data is stored again. What should these different models show you? They should show you that it would be difficult to regulate all these data trusts in the same way. If, for example, the legislator decides to make a data trust mandatory, the question arises for whom it is mandatory and what happens if it is not used despite the obligation. Each of these basic models can take on further function, for example, pseudonymization, anonymization, analyzing of data, etc. Depending on which function a data trust is allowed to perform, this in turn triggers specific regulatory requirements. Based on these different basic models, our study analyzes 3 different problems that data trusts can be considered to solve. These problems arise in the healthcare sector, in the online sector, and in the mobility sector, and I will now very briefly present the healthcare and the online sector, and then hand over to my colleague Wolfgang Kerber, who will present to you the mobility sector, and who will make the concluding remarks. And I'm afraid I will need 2 more minutes than I'm allowed to speak. Next slide, please. So let us look at what is required in the healthcare sector. In the healthcare sector, we face the problem of an underuse of data for research purposes. This problem mainly results from legal uncertainty, especially in data protection law. Data protection law does not prevent data processing for research purposes. On the contrary, it allows data processing for research purposes under easier conditions than data processing for other purposes. The condition, however, is that either consent for the data processing is obtained or that a balancing of interest is in favor of the data processing. A balancing of interest always means that it cannot be predicted with certainty whether data processing will lead to a data protection breach. In case of doubt, it is therefore better to refrain from data processing. One solution could be to allow data processing in data clean rooms that meet the highest IT security standards and ensure that only research projects which are in the public interest are carried out, and that the data cannot be accessed not even by the data providers. Only the results of the data analysis are made available to the outside world. Data clean rooms should be bound to the interest of other people, for example, the data subjects and the data providers, and they are data trusts for that reason. Other opinions hold that these data clean rooms must be offered by the states, and we are open to both solutions. Next slide, please. We have two more requirements in the healthcare sector, which I will address only very briefly now. First, in the healthcare sector, we have lots of data already stored in different registers, but it is difficult to find these data. Hence, we need a coordinating body. Second, in several countries, we have electronic patient records, and especially in Germany, we want to allow the donation, I say donation, of this data for research purposes, and I think this is a solution we should strongly support. Next slide, please. Now, what is the problem in the online sector? In the online sector, in contrast to the healthcare sector, there is not an underuse of data, but an overuse of personal data, partly in violation of data protection law. This overuse of personal data is mainly due to an information overload of the users. No one reads data protection declarations, neither I do, but also to an enforcement deficit in data protection law. What is needed is a solution that gives us better control over our data. Personal information management systems are this solution. Data trust in form of PIMS can perform the function of a consent assistance. That means that they can give consent on behalf of the data subject according to the conditions specified in the trust agreement between the data subject and the PIMS, and transfer the data covered by the consent to the respective processor. PIMS could advise users also when it comes to terms and conditions which users do not understand. They could better communicate the information to the users and therefore help to reduce the problem of information overload. It is conceivable that they can also enforce data subjects' rights under data protection law. Next slide, please. PIMS already exist in the market, but they are not really accepted because the benefits for the data subjects are missing. To change this, we need, and this is a core message from our study, which I like to draw your attention to, which needs regulation on the system level. What does that mean? We need fundamental decisions first. We need an obligation to comply with the instructions of PIMS. Otherwise, there will never be a benefit for the users of PIMS. Second, we need interoperability standards. At the moment, however, regulation focuses on details, especially on measures to minimize risk of PIMS. We need these details too, but we must prioritize system-level regulation. I say it again because it is so important. If PIMS are to succeed, data processors must be required to comply with their instructions. Without this requirement, any regulation of PIMS is pointless because it will not lead to users taking advantage of PIMS. And one last point, there must be a decision on the possibilities and of the financing and the organization of PIMS. If PIMS are to be allowed to be offered by private parties, they must be able to operate economically. To avoid false incentives, however, they should firstly not be allowed to monetize personal data, but only services. There's no problem to monetize services. And secondly, they should not be paid by the data processors, but must be financed by the users. And in order to avoid a situation in which the use of PIMS and thus effective data and consumer protection is dependent on income, we would like to avoid this situation. Therefore, we should take a consideration of subsidy models. Thank you very much for your attention. I now hand over to Wolfgang Kerber. Thank you again.
Thank you, Louisa. Now the last case study, and this is now about mobility data. So we know that data in the mobility sector are very valuable, and there are many different types of mobility data, but I will look at a very specific one, and these are the data that are generated in connected cars. And in the future, many data will be generated in the connected cars. And therefore, this is a very valuable and important data set. And the question is, what should be the governance of the data, of these data? And this goes back to a discussion we have already for some years at the European Commission. And this is a question about the extended vehicle concept of the car manufacturers. Because what has happened right now is that the car manufacturers have agreed to specific governance concept for the data in connected car, which would give them exclusive control on these data. and we will see this will lead to problems. So the point is that millions and millions of car users generate these data, and there are also many firms who want to use these data for services, but also for the general data economy, and also for public institutions, for public interest, and also for research. And the problem is, how can these data be really now governed in an efficient way? The point is that the extended vehicle concept of the car manufacturers leads to the situation that all data are directly transmitted to the proprietary servers of the vehicle manufacturers, and therefore the vehicle manufacturers get exclusive control of all these data, and they have exclusive control of the access to the in-vehicle data, and also exclusive control of the technical access to the car, also the remote access. And this means that they are constructing the car as closed systems, and there is no indoor building. And this means that the car manufacturers get the position of really a gatekeeper here into the whole ecosystem of connected and automated driving. And this allows these vehicle manufacturers to control all secondary markets where service providers need access to the car or to these data, and for close independent service providers and leveraging market powers to all these markets. And this has negative effects on innovation, on competition, and also on consumer choice. Therefore, already some years ago, the independent service providers and also consumer associations demanded a regulatory solution for these problems. And this is on the policy agenda of the Commission since 2016-17 already. Now, what are alternative solutions for the problem? So alternative solutions, and these solutions are discussed since 2016, so they are not new. On the one hand, the so-called shared server solution, and the shared server solution would be the same technical solution, so all data of the connected car will be transmitted to a server outside of the car, but this server will not be under the control of the vehicle manufacturers, but under the control of a neutral entity, which then can give access in a non-discriminatory way to all stakeholders, including the car manufacturers. And this would be clearly a data trustee solution, and I will come back to this. And the other solution is much more far-reaching. This is the implementation of an onboard application platform. This means open, interoperable telematics platforms, which would allow storing the data directly in the car and also would give the car owners directly the control over the data and the access to the car, so they have control about the car and the data. And both solutions would eliminate these gatekeeper positions of the vehicle manufacturers and therefore would solve these competition and innovation and consumer choice problems. And this is what's on the political agenda since 2018 and 16-17. And the Commission has commissioned a study, that's the TRL study 2017, where was clearly came the clear solution result that both solutions, the shared server and the onboard application platform, is superior to the extended vehicle concept because of these competition problems, and also the security problems can be solved with these other solutions because it's always the argument of the car manufacturers. Now, the Commission has acknowledged this problem. Since 2018, it's officially on the table for decision, and also the European Parliament has got active with a resolution in that respect. And but up to now, no policy proposal was really put on the table. Also, the Commission has several times announced, especially announcing a reform of the type approval regulation. Now, what are the discussions that are now discussed? It is on one hand a strict regulatory FRAND solution. So FRAND is fair, reasonable, and non-discriminatory access to these data of the extended vehicle. And it's not only about access to the data, but also to the car. So it's about also an interoperability solution and under FRAND conditions. And this could be done via another reform of the type approval regulation for motor vehicles. Second, the onboard application platform. This would be a very good long-term solution because it would lead to a different technological solution, which would allow really that the car owners get directly control over these data in the car, and therefore competition is directly possible. And the third solution, and this is what we thought about as a solution which is so far not so much discussed, is a data trustee solution for this. So the idea is that the legislator establishes a data trustee which gets control over all these in-vehicle data and which gets a task of giving access to these data according to the objectives defined by the legislator and certain principles, for example, also front principles. And this is then for firms, this is then for public institutions, for policies in public interest, but also for research. But what is also necessary is you would still need a regulatory solution also regarding to interoperability and security, because this is necessary for all solutions. The interesting thing is with a data trust that this would gives the perspective of that all these huge amount of mobility data that will be generated through connected and automatic cars could be seen as a kind of an infrastructure now that can be used by others for innovation, and would also help for the public policy objectives and also solve these competition problems. And therefore, this would be an interesting solution. It's clear that this has to be elaborated more. We only can sketch this a bit in our study, but we think this might be an interesting further solution. Now, the last slide is only a bit summarizing here. In regard to the three examples, so in regard to healthcare, it's mostly about better and easier data sharing of personal data. In the mobility sector, it is about avoiding this data exclusivity, so this extended vehicle concept and the ensuing competition problems. And in regard to the online sector with the PIMS, it's really about getting better control about the processing of one's own personal data. Okay, thank you very much.
Thank you so much, Wolfgang and Louisa. I would like to invite you, Wolfgang, to join our panel now, and also Dr. Nils Börnsen from the Federal Ministry of for Economic Affairs and Energy. He's a lawyer by training, and he joins us from his unit, which is actually also Thorsten Käseberg's unit on competition policy, cartel law, and digitalization. You are a little bit of, well, the competition policy guy, you told me, coming, well, straight from the engine room. So we do hope we can give those kind of concepts and characterizations that we just heard in the presentation a little bit of a reality and maybe practice kind of check. I should have also really introduced to you Wolfgang Kerber and Louisa Specht-Riemenschneider properly, which I've forgotten, shame on me. But I will briefly do that. So Louisa Specht-Riemenschneider, as you may have guessed, she's a lawyer. She's a professor at the University of Bonn for civil law and information and data law. And she's also a director of research, director of the Research Center for New Technologies and Data Law at the University of Bonn. What I find interesting is actually her most recent also position that she holds among many. She's a board member of the OECD's Consumer Policy Advisory Group on Dark Patterns. That's an interesting one. And Wolfgang Kerber, he's a professor for economics at the University of Marburg. One interesting bit in your career I found a very long time ago is that you were once the director of the Walter Eucken Institute in Freiburg. Anyone who knows the history of German order liberalism will have heard of Walter Eucken, and the Walter Eucken Institute is one of the guardians of that heritage. And keeping with that, he's got a strong interest in competition policy, intellectual property, research, and any kind of research at the crossroads of law, economics, and political science. Before we kick off our questions, I should say one more thing. There will be space for audience questions, so please do think about questions. Make yourself known or heard, raise your hand, and I will try to get to you as soon as possible. Maybe to kick us off, I would like to start with a really broad question. I'm going to come up here. To you, Nils. So what you heard in terms of the characterizations about, different types or categories and maybe also sectoral applications of data trusts, in your practical work, does that kind of ring a bell? Does it make sense, or what is your reflection on that?
Yes, many thanks for having me. It's an interesting one because, as you said, I'm working in the competition bubble, if you want to say so, and competition law, as you know, is horizontal. So we are aware of the problems of bringing things together from various angles and various sectors. And what you see very good in the study, I think, is that we're talking about very different things here. And it's very difficult to find the common denominator here to say, like, is there really the one data trust or the one data intermediary solution which will be the one-size-fits-all approach? Probably not. I think the authors of the studies share the same opinion, but I think that, yeah, that clearly does ring a bell. Like, speaking from my experience from the engine room, as you said.
Thank you. You were highlighting something that Louisa has been highlighting as well, in a way, that there is, of course, kind of a challenge in regulating either data trusts or regulating for data trusts, in that you need sort of, to some degree, a horizontal approach. You can only do that, however, to a certain level, because as soon as you get into the specifics of certain applications, you will necessarily get down into sectoral law solutions and thoughts. Now, Louisa, I would like to ask you, in going back to that kind of thought, isn't there a risk then that you end up again with a highly specialized set of regulations and special cases that are so fragmented that, of course, you cannot have a one-size-fits-all solution, but too much fragmentation isn't really helpful either. So I do wonder if there is a need for, sectoral specific and therefore somewhat fragmented legislation. Are there still some, cross-sectoral kind of lessons learned that you could draw from your sectoral studies, even if it's only the kind of questions that regulations would need to answer?
I'm skeptical on the horizontal approach of regulating data trust. The takeaways here: avoid one-size-fits-all solution, but maybe we can agree on, well, we need to look at the problems we want to solve. There could be a horizontal takeaway, but this horizontal takeaway will end up in sector-specific regulation. And I'm not sure if I agree on your opinion that sector-specific regulation is no good. I don't think we have any problems with this sector-specific regulation, as long as it solves problems which occur only in this sector and which are very, very specific. And I think data trusts are are part of a solution which always is very, very specific. So yeah, our study and I'm personally quite skeptical as to whether this really requires horizontal guidelines, and if horizontal guidelines would really be beneficial here.
Okay. Yes, of course, Wolfgang.
I think this is a very important question, and I think there's always a trade-off between horizontal and sectoral solutions. And the problem is, and I think this is also what you alluded to, that we cannot all problems solve with a sectoral solution. This is also not possible. Yeah. So in that respect, we also have to have a step-by-step approach. But I think what's important is that we look at specific problems which are very clear, but also which are large clear. I think the data in connected car is a good example for this. And look what specific problems is there, and can we find a sectoral solution? And it's very clear we already have a sectoral solution from the past here, and therefore this might be a good idea here. But it's also clear that we cannot do this with all specific problems. So in that respect, this problem still exists, and we have to deal with it. And what we can do in any case is we can really learn from different solutions, also for the sectoral solution. I think this we can do in any case. Yeah, but it's a problem which cannot entirely solved. I agree.
Okay. Maybe just another thing I want to dig on deeper, or dig into deeper. If you certainly one thing that thinking about sectoral approaches helps us to do is to think about the previous examples, the previous cases where you have solved a problem that exists, and also where we have made already effectively political, maybe also societal choices in favor one solution over another, in favor of, let's say, competition over concentration. How would you say does that relate to your example, for example, in the mobility sector, and maybe also in other sectors?
I mean, if we look at this connected car example, this is a very specific example, I agree. On the other hand, behind this, it's a smart device, a connected car. So in that respect, it is only an example for an IoT problem. And we have similar problems also for other smart devices. So what we see in nearly all smart devices is that the manufacturer of the device usually wants to get all the data and exclusive control of the data that the device is producing. Also, the users are generating the data. Yeah, and this we see very prominently in smart agriculture, in the agricultural sector, where this is also much discussed, the problem that manufacturers of the smart farm machinery collect data, and the manufacturers have the data and not the farmers, and this has been discussed as a huge problem. But we also see this with other smart devices. So in that respect, this problem is in different IoT contexts, but might then also have different aspects. So for example, in the example of smart agriculture, it is a farmer who is working with this, is not a consumer. So, yeah, and therefore there are differences, and then we have to think about what does this mean.
Yes, please.
Maybe if I can jump in on that point, because competition might be one of the links between the sectors and the sector-specific cases. And we see, I think, yes, there are familiar problems in several sectors, and of course, it's not everywhere a completely new problem. But still, if you look at the sectors, well, and if you focus on competition only, by the way, I think one point where the study is very clear and very helpful is in its finding, be very specific about the purpose of designing the data trust or designing the tool, whatever. It helps to build you an efficient tool. That's something which is really helpful for our work, of course, as well. But even if you do that, and if you focus only on the competition side of the problem, and if you take only one sector, for example, the vehicle data, even then you have several layers. I mean, I think the sector study is very clear and very helpful. And you can see very well that you're not only talking about the competition between the OEMs and the aftermarkets, you're not only talking about the competition relation between OEMs and users, you're also talking about big tech and OEMs. And their a solution like a data trust or data access rights or whatever can help for a particular level of this competition problem, but be detrimental on the other level. For example, if you open up the data and it, in the end, aggravates the problem of market concentration because the data you have opened up by that right to access to data ends up with a big tech or with the dominant player, even if it's not big tech, then you might found a solution to the one level, but not to the other. So jumping back to your question, it's very difficult to extrapolate from one case study to the other.
Maybe bringing on that topic of what's the sort of complementary instruments and tools that needs to be applied to make data trust really work. Bringing in back Louisa, you alluded at one point, I think it was in the PIMS example, that a data trust in a way is only ever, it can only help to solve problems really if it is applied together with other instruments. I think you mentioned interoperability, and can you maybe explain or explore that thought a little bit further?
Yeah, of course. I think one big misunderstanding in the current discussion is that data trustees are called the one and only solution for many problems. But they are neither the one and only solution for many problems, nor are they the solution. They are only part of a solution. They are always only part of a solution. And they must be accompanied by other measures. And we mentioned in our study that this could be interoperability standards, or yeah, always, or not always, but mostly are interoperability standards, and could also be, for example, data access rights. And why is that the case? Because the data trust is always the infrastructure, and the best infrastructure does not help if data sharing does not work, because no one wants to share the data. So if we get to the problem that this is the case, and we want to make the data being shared, then we need data access rights. But this is only one example of a measure which could accompany the data trust solution. What is important is that the data trust is not the solution itself, but can only be part of a solution and must be accompanied by different other measures.
Yes, you want to react to that, Wolfgang?
Yeah, I would like to add a bit in that sense that what's very important is that you always start with the problem that it has to be solved. So what is the problem that should be solved, and what are then the purposes of this, and then ask what you need. And then the point is the data trust might be a solution, but then in order that you really have an effective solution, you might need to complement this with other regulations. So I think a very good example is the Second Payment Service Directive, so the PSD2. So PSD2 is really a very complex regulation. You have, on one hand, you have a data access regulation. Yeah. On the other hand, you also have really a regulation in regard to security, and you have a regulation with interoperability, and you have a fee regulation, and you have a special regulator about this. So you have a whole complex of regulation, and only the combination of all these regulations can make this effective. And if one is missing, it will not work. And I think this always has to thought about what really do you need for solving a problem. So you have always start with a problem, and then data trust can be a solution. But the question is, what do you need else? And this can be different.
Yes, please.
No, I just wanted to underline that like within the competition bubble, we have discussed data access right quite a lot. We have discussed interoperability, and we are still discussing it in the DMA. Data trust, no, not yet. I haven't heard that so much, but that they could have a potential. Where exactly, again, you have to be specific. It could be a solution to the problem that when you have a data access right under competition law, for example, or sector specific, but then you have a conflicting right of a third party, for example, because the data you want to access is personal data, or because it's a business secret. And then data trust could provide a technical solution to that problem, that you have conflicting interests of like an access right on the one hand and a right of the data to be protected on the other side. On a regulatory level, that's often not, there's no solution to that. We find, if you look at the regulation, then you find clauses such as without prejudice to the GDPR, or without prejudice to this and that regulation. But the conflict itself is rarely solved. And this is where data trust could come in as a technical solution. And then jumping back to the competition policy level, that of course is interesting, because you could open up data for competition and mobilize data for competition without having to lower the level of protection of such data. So that's where the competition angle comes in. But again, that's only one piece of the puzzle, of course.
We do have a first question.
Let me please just very quickly jump in and support that. This is a very important possible function of a data trustee, just harmonizing the conflicting rights, or even maybe lowering competition risk, because you can just process data in a secure space, and no data just goes out. Yeah, this may lower competition problems.
Thank you, Louisa. We do have a first question from the audience, please.
Oh, is it working? Yeah, it's working.
Now it's working.
Amazing. So first of all, thanks. It's super interesting for me to listen to what you're talking about. I'm Damien Bislager. I'm a member of the European Parliament, and yesterday night we finished the negotiation of the Data Governance Act, and so we had a horizontal approach to data intermediaries, as Louisa also very well knows, and so I will try to defend this kind of horizontal approach, because there was a bit of a question whether you have to go sectoral and horizontal, and I do believe that learning from the different problems can then maybe help you understand the horizontal level a bit better. But I mean, if I look at the different case studies that you presented, I think we have to understand that there's a different level of sophistication of regulation when it comes to personal and non-personal data. Because for personal data, obviously, we have already established with GDPR that somehow the end user, or whatever you want to call him, is in charge of that. And then the question is, how can you give meaningful control and access to this end user to actually execute that right? So that's a tool of data trusts can help to actually help them, be meaningful in the execution of that right. But in the cases of IoT and Internet of Things and end users, when it comes to cars or farm equipment or whatever it is, we don't have that regulated yet. And so I believe that there is a horizontal need to regulate who has meaningful access and should have meaningful access and control over the data that they're producing. And it's a bit of a principled question, and that's why I think there is a bit of a horizontal need, especially because obviously you have to weigh the production process of the data when you're actually using the car versus the effort to create the software that then will actually generate this data, and the incentives need to be clear. But I think there is the question of how we do that, and then we can think about the more horizontal, so the more vertical solutions, and also more the tools that then make this meaningful with data trust and so on. So I was just wondering whether you could react to this question of we still need a horizontal approach when it comes to non-personal data.
Thank you. And I guess also how you rate that opportunity for learning spillovers in other sectors. I'm not sure who wants to react. I guess maybe Louisa, and yeah.
Yeah, maybe just very quickly. Thank you very much, Damien. You know that I'm not very happy with the Data Governance Act, as it also regulates PIMS. I'm kind of happy with it for big data intermediaries, but we talked about that before. Let me just very quickly correspond to two aspects you spoke of. First is personal data is regulated in the GDPR and not in the Data Governance Act. I think that's exactly the problem, that the GDPR isn't opened up, and GDPR and Data Governance Act are not thought of together. The second point is, do we need horizontal regulation for non-personal data? I'm not sure. Maybe, Wolfgang, this is better for you to answer. Maybe, yeah, out of competition reasons, that might be a point, but not for data trusts, maybe more for data intermediaries.
Perhaps I can step in here. I mean, data are non-rivalrous, meaning that many firms can use the same data. And this is a problem, because this is a chance. This is very good, but it's also a problem, because this leads to the consequence that any solution where one party has exclusive control over these data might be a problem. And this is exactly what we have here in the connected car example, where the car manufacturers get exclusive control over the data, and this leads to problems. Now, there was already a proposal for a horizontal solution for exactly for smart devices, and this was a proposal for a data producer right in 2017 of the European Commission in this communication building a European data economy. And they made this proposal exactly for smart devices. And they said that the owners or users of a smart device should have exclusive control over these data. This was a proposal. This was data producer right. And this then did not really, was a lot of resistance against this, also sometimes of good arguments. But is a bit this experience. So this was already something. And the problem is really that with data, we should more think about not that one entity should have exclusive rights, but that this is something which many can use. I have this called, in one of my articles, a multi-stakeholder problem, yeah, where there are several who can use the Jaeger, and then we should have perhaps also rights of different stakeholders or of many stakeholders using the same data. And this is on an extreme form. This is open data. Open data is that anybody can use it. It's an extreme form. But in a less extreme form, it could also be that you take exactly this idea of a data trust, where you put the data in, and then someone, the legislator, decides which groups should get, under which conditions, what kind of access to this data. And this then can be used, for example, for training algorithms. This is anonymized data sets, yeah, and or opening certain kinds of data sets really for new startups, etc. And then you do not have that one entity has exclusive controls. This is a problem with the data. And this is different for personal data, because the personal data we think, okay, the person should have this right. This is different. But for non-personal data, it is not the case. And therefore, I think from that perspective also, data trust might be an interesting solution, at least for certain kind of data sets.
Thank you. Yes, Nils.
I wanted to add one other aspect, and we haven't discussed this yet, but I know you're aware of that, and I know that you're doing a tremendous job in designing the Data Governance Act, and it's really great work. But I think there are two elephants in the room, and I think you are aware of it. But the two questions are: who's going to do it? We're talking about a market which is not developed yet. You have actors in the market, but quite a few. They are not as big as people want them to have. And the second one is, who's going to do it? Like, who has the incentive to do that? We heard a bit about that in the study. Of course, there are different models. Of course, you can think about various things. But the question is, if you try to regulate that market before it has really developed, you can do that. Maybe that's a smart idea, to develop a market by regulation, if you want to say so. If the central problem is lack of trust, maybe that could be the solution. But the incentives are so various in the sectors that there is a potential risk, I would say, that's my personal opinion, I'm not speaking for the ministry there, that you cannot catch the incentives correctly, and you might end up with a design which creates, like, oversimplifies or like destroys incentives at a point where you might need them for actors to come in and to develop those solutions, which we all hope to have soon.
Thank you so much. Maybe we can just have a very brief closing round, because that, I think what you just said, we are really at the conception kind of stage. We are at the initial development phase of potentially a new market. Brings us to what I would like to ask you as a closing question, and maybe we can start with Wolfgang. So we've just heard from Nils that this market, it's all not really developed yet. We don't know where it's going yet. Let's say we meet again in 5 years and we sit here. What will data trusts have done for the world?
I mean, this depends very much whether really data trusts are developed. And therefore, I'm so far a bit skeptical about this, because I do not see really that the preconditions for data trusts are really here so far. We have seen the PIMS, so I think we need really preconditions on the systems level. And with interoperability and with this obligation to really cooperate with these PIMS. And if we don't have this, then I think we will not get a market for this. And therefore, this has to be done. And I think this is really also a task really of the regulator, of the legislator here, to set really this right framework of rules. And we've talked about this for enabling this.
Louisa, I guess you would agree with the PIMS bit, but are you as skeptical?
No, I would very much agree to what Wolfgang just said. let's not only think about the risk of data trustees and especially of PIMS. Let's see how they can help us, and they can tremendously help us. And then let's accompany the measures to minimize risks by measures which give incentives for the creation of PIMS, for the functioning of PIMS. And yeah, let's enable them to solve the problems we want them to solve.
Niels, I guess you feel the burden of expectations. Where do you want to go with that in the next 5 years?
Well, we're talking about hopes here, right? So I hope in 5 years when we meet again that we see successful stories of data trusts or data intermediaries in various sectors, and I hope that they play a vital role in solving the problem they were designed for. Let it be data protection, let it be control of my personal data, let it be competition. Maybe the purposes can join, and you have data trustees which solve several problems at a time even better. But I hope that would be my hope, that at least we find successful stories in 5 years.
Thank you so much. Thank you very much for that insightful presentation and the really interesting panel. I guess at some point in the new year, everyone will get to read the new study on designing data trusts. Until then, I think Pencho has got a very honorable task to do.
Thank you. The late night show goes to end. European Data Summit, day 1st. As promised, we are going to deliver the paper in the beginning of January. Earlier wasn't possible, and we really congratulate the European Parliament for the great job with the Data Governance Act. We are looking for the incentives still, and we're going to discuss it tomorrow with you again. Now, I would like to remind you that we're going to start tomorrow at 8:45. Don't miss the unintended consequences of the GDPR with Winfried Weil. And we have many more interesting speakers. Just to mention a couple of them: Audrey Tang, Gary Davis, and we would like to move also from strategy to execution when it comes to data sovereignty. So we're glad to see you tomorrow again. And now we are inviting you for a glass of wine. Many thanks.